Welcome to the Weekender, episode 73 and a half. We're giving it another shot here. We're a little bit worried about what we've been saying, so we brought our counselor.
Yeah, I have to have an attorney between us just to get along.
I am the Switzerland of signature.
There you go. So,
Well, definitely special guest, Dave Sanders. And if you have any legal questions like we do, he's our go-to.
right?
Happy to be here.
If you have any questions, feel free to put them in the comments. Maybe he'll answer them. Who knows?
Yeah. So,
Probably not.
Nope.
so believe it or not, when I was on the board, I had Dave there at my board meetings all the time, and so I had to be careful what I said because Dave would tell me the legal ramifications of what I'm doing, like name changes and anything like that, for the board. And then, but you don't have a Dave at your board meeting, so it's a different type of meeting.
So I miss Dave too because I was on the forums committee for many years, and he was at every one of those meetings. And I was chair one year, but I think it was really Dave that ran the meetings because he did all the work.
No, you guys all contributed. I was just there to
We tried a little.
answer
We
questions.
tried. No, and even when I sat on the board, he was in the room too. So you're missed.
Well, I'm happy to be where I am.
Yeah, you're doing well.
We're
So-
happy you're where you're at too, because we get to utilize you more now. So just want to remind everybody, if you've dealt with a real estate form, most likely Dave helped create it. And so if you have any issues or problems, make sure to dial his 1-800 number, and we'll work on getting those fixed.
1-800 Tom shirt.
Yeah.
We got to get that in every week.
Somebody asked me why the Tom shirt thing the other day, so maybe we should explain it again so they don't think we're
Have you
crazy.
seen his shirt?
Yeah, that's true. So a couple of episodes ago, I wasn't here, and the most shining thing that came out of the episode was Tom's flowery shirt, and so it's been a proud sponsor of our show ever since. So
Well, it's one of the most requested guests.
not even Tom, just the shirt.
Just the shirt. So, but maybe you will be too. So we're good. So what do we want to ask him, Chris?
Well, I want to start off, one of the things that's happened, our market's changed a lot, and people are scammering for every property that they can get, and it's a really tight, tough market. And we have a lot of clients that are just willing to go out there and pay whatever it takes to get a house. And I know you've sat on a lot of hearings and been in a lot of those panels, and so let's kind of talk about the fact of the client saying, I think I paid too much for the house. What happens in that instance?
Well, I'm sorry they feel that way, but
It depends.
It depends.
so
That's what I was going for.
A purchase agreement is a contract between a buyer and seller. The appraisal comes in because you are trying to convince a bank to give you money. But to be honest, if I want to pay you $1 million for your condo off of D Street downtown, it's nothing illegal about doing that. There's not a specific price point that's established by statute or by law. So if the parties agree to pay whatever they want to, they can do that. Just like when a large company buys tries to buy out a smaller company, they pay, hundreds of millions of dollars, and then a year later, the valuation of that company is $40 million. They don't get to try to turn around, unless there's been some kind of fraud or deceit. Just because they feel like I paid too much doesn't mean you get to, sue Chrysler because you felt you paid too much for your Sebring, which frankly, if you bought a Sebring, you paid too much.
I had a Sebring. I love that car.
Did you feel like you got your value out of it?
I did. I felt that way.
So that's the point. You can pay whatever you want to. The reason why we have the appraisal contingency in the contract is because the fact that a bank is going to be giving you money.
Sure.
And the bank is going to say, we're not going to give this too much because they're leveraging the fact that if you don't pay, they get the asset back and they can turn around and sell it and recoup some of their profits.
They don't want the Sebring back.
Not after what I did to that car.
So that's where it comes from. I mean, the reality is the market's going to bear whatever price points it is. Like,
Sure.
if you're anything like my father would drive around the entire town to find a gas station that is a penny less than the rest. But I also know other people that would just drive to the closest gas station and fill the tank because,
That's me.
1 penny on a 16-gallon tank is 16 cents. It may not be worth the effort, but gas stations set their prices. There's different prices. You can see them in every neighborhood you go into. It's very much the same thing. So in this market,
He said it depends. I heard that come out of his mouth. It was depends.
I think
Took 2 minutes in. You're welcome.
your biggest problem would be somebody thinking you underpriced the home, wouldn't
Yes,
it?
yeah.
Especially in this market.
Seller thinking that they didn't get enough.
well, the key, I think, for you as a real estate professional is to make sure you have your paperwork and justification. If you pulled the appropriate comps, if a seller came to you and said you underpriced, if you had the appropriate comps and they brought a lawsuit or they brought an ethics complaint, my defense would be this is the standard in the industry. They pulled the comps. They pointed out, the price point that was valid. You accepted that. You signed the contract. So,
Makes sense.
People are going to be unhappy. That's kind of the nature of some things. When there's transactions, it doesn't mean that you necessarily did anything wrong just because the seller thinks that they maybe could have got a little bit more. But if you've got the comps, if you're doing your job, if you're complying with NRS 645 and the Realtor Code of Ethics,
Nothing to worry about.
I'd feel comfortable making that argument in front of the commissioners or a panel.
So let me ask you this question, because this is coming up a lot. We have different websites that are out there, different referral groups, different programs, and we see a lot of agents start, sharing their opinions on everything, good, bad, or indifferent, bashing other agents, bashing other companies. And Brandon and I made a commitment that on this show, we would never bash another individual, even those we like. Even Tom's shirt, we try not to bash it, we just bring it up a lot. But why shouldn't they be doing that, and what do they need to be cognizant of?
Well, there's a couple of things that you need to be concerned about. First of all, the Realtor Code of Ethics applies. It has a higher standard than, believe it or not, slander and defamation does. The Realtor Code of Ethics says that you cannot talk, unkindly about another realtor's business, even if it's true. So you're running into a potential Realtor Code of Ethics violation. Slander and defamation still apply to comments that you make online, as do antitrust issues. When I was the in-house counsel for the realtors, I really wished I could have convinced the board of directors to cancel all of their social media, but nobody listened to me because that's the easiest answer, but no one wants to hear that.
Those crazy ideas have no place in our association.
What I would tell you is you need to be mindful of what you put on social media,
Yes.
and I'm going to give you advice that I gave everybody else. Do not put anything on social media that you wouldn't want your mother, your religious leader, or a jury of your peers to see. And my favorite example of that, and you probably remember this, is there was a Boy Scout troop in Utah that videotaped them in Goblin Valley, which is a federal landmark, pushing over a bunch of rocks that had been sitting there for about 3 minutes.
Yeah.
And they claimed they were doing it for safety. They cheered, and cheered. Here's the thing that you may not have known about. Now, so not only did they get kicked out of the Boy Scouts, they got indicted by the federal government, but here's the big kicker. The guy who was pushing the rocks over was literally suing his employer, claiming that he had permanent back injuries that precluded him from ever going back to work again. So guess what the defense lawyers did? They found the video.
Sure.
Guess what happened to his lawsuit?
He didn't win
It went
it.
away. So be very mindful of this. Anything you post online, I would be very, very careful. Just like I don't tell you to, any group on social media that's not a closed signature group, I wouldn't be asking for advice. Might rhyme with bad coats. I don't know. I wouldn't be going online for these quote-unquote experts for advice on what to do in your transactions. Frankly, that's why you have the brokers you have here.
Yeah.
That's part of the reason why you came to Signature is that you have this kind of support. Why would you go online and ask a question to somebody who frankly isn't doing enough business, who has more than enough time to troll Facebook all day long?
True that.
So John Gafford put out a post a few weeks back, and I thought it was actually really brilliant because he talked just about that. He says, you guys should just all unsubscribe to these things, stop talking on it, stop communicating. Part of the thing I see is that the problem is if you comment and you don't even necessarily say anything bad or antitrust, but
You're
now
still
you're part of
involved.
the thread, and those things can go pretty deep,
Yep.
and then antitrust comes into it, could you be liable there?
Yes, so just to freak you out even more than we already have, antitrust laws do not require an intent provision. Meaning I don't have to intend to violate federal antitrust laws. My intention can be implied from my actions, meaning what Brandon just said. If I'm making comments on a social media post where then someone says, let's ban this group, let's discriminate against this group, guess what? They can go after you for that. There was a group of, I want to say about 40, 50 dentists in Florida who had a closed Facebook page about 10 years ago. They were all busted under criminal provisions under the federal antitrust laws for price-fixing dentures in Florida.
Wow.
So, just because you have a quote-unquote closed Facebook page, it doesn't mean that an attorney or a law enforcement officer can't get a subpoena to get those documents. That doesn't mean you're protected at all. And so I'd be very, very mindful of what you say on social media. Plus, let's not even talking about the fact that the division loves to search that kind of stuff for complaints as well.
That case sounds like a real nail biter, I know.
Maybe a tooth grinder?
Bump, bump.
So,
Hey,
go ahead.
I would never talk bad about another show or group because I wouldn't want to expose the problems that they could have from it. So
I love how you just took a jab at my podcast.
right. So
Oh,
Dave,
Vaughn and his podcast. I'm just part of the show.
Dave, right now with everything going on in the marketplace, one of the big questions I have for you is that we have a lot of agents now that are closing tons of transactions. The deal gets completed, and then down the road, something happens to the property. There's some after repair or item or cracked pipe or something like that, and the seller comes back and says, "Hey, I didn't know anything about it." And the buyer's like, "Well, I just bought the house and now it happened." What is the agent's role in that responsibility? What is our job, and how should we handle something like that?
So we really need to talk about two different pathways, if you will, related to the condition of the property. The first is, of course, the contractual obligations arised under Section 7 of the RPA that we talk about, the due diligence period, the request for repairs, those contractual obligations that buyer and seller agree to repair. Then there's the SRPD, which is a completely different animal. So the SRPD, does anybody know who actually enforces the SRPD?
I'm hoping somebody at the state, right?
It's
Depends.
It's the courthouse. It's actually the courthouse.
Depends.
So the only part that the real estate division has in the SRPD, which is created under NRS 113, is the legislature says the real estate division has to write the form, and that's it. Any other dispute, the place you go and resolve a dispute over what should have or should not have been disclosed under the SRPD is a lawsuit. So the answer comes down to a twofold thing. So, if you're relying on your appraisal and your inspections and they're telling you need to do repairs, that is your obligation under the RPA. And you have the obligation to recommend to your client that they do whatever kind of repairs they need to do. The SRPD disclosure is very, very clear. The real estate agent is not responsible for anything under it. They just have to have the seller fill the form out. They're not responsible to do investigations, to do any kind of anything beyond that, except for hand the form over to their client and say you need to fill this out.
Sure.
The buyer, the SRPD is not a shield or an absolution of responsibility for them to do their due diligence, to conduct investigations. For example, if you have an inspection and the inspection says, buyer should really look at this, I'm not an expert, buyer should look at the water purification system, it's outside my scope. If there's a problem with the water purification system down
Don't
the
drink
road,
the water.
well, yes.
Tastes okay to me.
But also there's a specific provision under NRS 113 that says this doesn't absolve the buyer for doing their due diligence. And if they're on notice, then they can't come after them after the fact. So the SRPD, you have to have your client execute it. You have to have the buyer has to acknowledge receipt. But if there's any problems with it after the transaction, that's not necessarily, you can certainly help your client with paperwork and things like that, but unless they can resolve it, the place they're going to go is, of course, mediation if they sign the mediation provision in the RPA, and then after that's going to be a lawsuit. So whenever you hear about failures of a seller to disclose under SRPD, it's typically when the lawsuit hits the courthouse.
Yeah.
So if you're doing your due diligence under the RPA and you're providing your client all that information, that's one thing. If there discovers a condition that wasn't disclosed, your job isn't to be an inspector to go out there and find that, but you can certainly work with your client and help them with those documentation, and then the first step after that would of course be mediation. So
Sure.
So
I'm not to be the inspector. I'm not to give any advice. I just pass information along to the parties, and that's my role.
the seller's obligation is just disclose everything that they're aware of. They don't even have to be an investigator.
So here's a question. So seller fills out the form, right? And I see this a lot. And then the form is delivered over to the buyer's agent or whatever, and the buyer's agent comes back and basically says, you need to check all these boxes, right? Does that open the liability for you now of interfering in the thing? Because this is what they provided.
Without saying it depends, why did the buyer's agent say you needed to check these boxes?
Because their broker wants them to make sure that they're all checked so that they can get paid.
So if the form isn't completely filled out, it's not accurate under SRPD, under state law. Whether a broker decides that we're not going to pay you unless the seller completes this form, I don't really know if that is a valid reason for a seller to change the form. That would be a very interesting argument to make in front of a judge. Unless they failed to complete the form, like there's boxes they didn't check, that would be a different story.
Like the one that says other?
Well,
Depends.
It depends.
Is there
I think to that same point, if I go back to my seller and say, hey, you missed a few of these boxes, do you want to fix them? And my seller says, nope, that's how I want it filled out, that's what I want done. Then I, as the agent, I've done my part. And then if I go to my buyer and say, hey, listen, we got this document, it's missing a bunch of blanks, what do you want to do? And they say, we'll go back and ask them some questions and find out why they didn't. And they say, go jump in a lake, and they move forward. I have something that shows that I did my part.
That warms my lawyer heart right there, because
See? Another happy lawyer.
Because the seller only runs into problems under the SRPD if they fail to disclose. It doesn't matter if the property isn't in pristine condition; they just have to disclose it. So the shower leak's great, mark it down. If you don't mark it down, then the damages provision kicks in, and they're entitled. So then the buyer is entitled to triple damages of what it actually costs them to repair, plus attorney's fees and costs, and that can get extremely costly. The SRPD cannot be waived; it's a statutory obligation. The only thing that you can waive under NRS 113, and why you would do this, I have no idea, is the buyer can waive their right to collect a remedy. So seller can't say, I'm not going to produce the SRPD. What the seller can say is, buyer, waive your right to remedies. I can't imagine you would ever do this, because trial consists of two parts. You have the...
Happy attorney?
Yes. Well, that's all the way through.
Yeah.
We're happy all the time in trial. You have the part where you determine who is responsible. Was the light red? Was the light green? Is this murder? Was this a leaky faucet? Yes, no. Then you prove damages. How much am I injured because of the car accident? How much did my roof repairs cost? Under the SRPD, you can waive the right to collect any money.
Huh?
So the buyer can say, I'll go to trial.
Can I waive the attorney's right to collect any money?
No,
Oh, damn.
that's not possible in America.
Yeah,
Which is what makes us great, frankly. No, so my point is that the buyer can waive their ability to collect anything. If you ever have a scenario, if you're an agent and you have a seller, you receive an SRPD where they want the buyer to waive this remedy, you need to run immediately to your broker, because they need to talk to an attorney, because what this seller is basically doing is saying, I'm not sure if I'm going to produce everything.
Sure.
I'm pretty sure there's some problems with the property. If you sue me, yep, I didn't disclose it, but there's no way for you to recover anything. And that, to me, is pretty horrible. So I'd be very, very careful with that.
So we're only a 25-minute show, and with any good attorney, we're almost done. And so
He's still paying for the whole hour.
yeah, he doesn't make change. I just want to say thank you, and your knowledge of our real estate industry is fantastic, and I know many out there have benefited from having you in their corner.
Glad to be here.
And really appreciate your insight, for sure.
Yeah, and if you want to hear more from Dave, in a couple weeks from now, he'll be at one of our sales meetings doing a legal update. Those are broadcast live on YouTube, and so we'd love to see you there. So, any parting words?
Remember Thursdays with Tom?
I'm never saying that out loud.
Well, not to expose any other secrets in the marketplace, but really have enjoyed this show. It's one of the best ones that I watch, and I do watch quite a few of them. So,
The Weekender?
Yeah.
It is a good show. So, with that, we're going to go ahead and sign off, and we'll see you next week. Thanks.
I feel the change coming, it's closer every day. I feel the waters rising.